Is gambling considered dissipation of assets? Have you ever wondered how gambling can impact a divorce? Specifically, is it seen as wasting marital assets? Let's break this down in a clear and straightforward way. Gambling is often viewed as a form of dissipation of assets during divorce proceedings. Dissipation refers to the misuse or waste of marital property, especially when one spouse spends money in a way that intentionally reduces the other spouse's share. When it comes to gambling, this behavior typically involves spending marital funds on activities that do not benefit the marriage. This can lead to a significant decrease in the marital estate, which is the total value of the couple's shared assets. Courts generally see this as economic misconduct. If one spouse has lost money through gambling, those losses can be charged against their share of the marital property during the division process. Timing and intent are key factors in determining whether gambling is considered dissipation. If the gambling occurs during the separation period or when divorce is imminent, and there is a clear intent to deprive the other spouse of their fair share, it is more likely to be classified as dissipation. Additionally, the amount spent on gambling matters. Occasional losses may not qualify as dissipation, but habitual gambling that drains marital funds usually does. To prove dissipation, the spouse making the claim must provide evidence. This can include financial records, bank statements, and credit card statements that show how marital assets were misused for gambling. If a court finds that dissipation has occurred, it can adjust the property division to account for the wasted assets. This means the spouse who gambled may receive a smaller share of the marital estate, reflecting the losses incurred. In some cases, the court may also consider the gambling spouse's future income and assets when determining compensation for the dissipated property. Gambling debts can also complicate matters. If these debts were incurred during the marriage, they may be treated as marital debts. However, if the debts stem from dissipation, the court may assign responsibility for those debts to the spouse who engaged in gambling. In summary, gambling is indeed considered a form of dissipation of assets in the context of divorce. It involves the intentional and excessive use of marital funds that can negatively affect the property division process. If you are facing a situation involving gambling and divorce, it is wise to gather thorough financial documentation and seek legal advice to protect your interests.